Hi, I'm Stephen Higgins. Welcome to the website Fight Your Tampa DUI. I'm one of the lawyers with Fine, Blue, and Hanel. One of the things I want to discuss with you today is what I always refer to as the first sort of continuum of events that takes place when you get arrested for DUI. It's the driving pattern. I always explain to my clients that the reason that the officer stopped them or the reason that the officer visually observed them is because of a driving pattern, whether it be running a red light, speeding down Kennedy or off on Adamo Drive, making a wrong-hand turn on a one-way street in Hyde Park, or coming out of Ybor after a long night of partying. The officer has some visual observation of your driving pattern which leads him to pull you over, that reasonable suspicion that you may be sick, tired, or impaired. This is the most critical portion of a DUI case. It's the portion of the case that we must challenge. A lot of times people will learn that if the stop of the vehicle is invalid or unlawful, everything for the rest of the case can be thrown out of court. We do that by way of a motion to suppress. We may argue to the court that the reason for the stop of your vehicle was invalid. Perhaps the officer stopped you for weaving, and that definition of weaving that's been defined over many, many years in case law, your driving pattern doesn't rise to the necessary weaving pattern that gave the officer probable cause to pull you over. This is a significant problem. If the officer doesn't pull you over for a good reason, for a legal reason, then there's the opportunity for us to get the entire case thrown out. I encourage you to call us today, 800-FIGHT-IT, 800-344-4848. Give us a call so that we can evaluate your case and determine whether or not there's an issue in terms of the officer pulling you over for an unlawful reason.